Welcome back, everybody, for session 5, Building and Mobilising Legal Capacity for the COVID-19 Response and for Legal Preparedness Beyond COVID-19. A reminder again for those who are joining us by Zoom, the forum is being live streamed on the Melbourne Law School's YouTube page, and we're recording, and we'll post the forum not long after the event concludes. So in this final session, we've been discussing over the last couple of days, the critical role of legal frameworks across a number of different priority areas and how important it is that we get our frameworks right, which is partly about law on the books, but it's about much more than that. It's also about how we're able to implement frameworks effectively in practice, how we can monitor their impacts, how we can monitor these impacts on different groups and individuals, and particularly on vulnerable, disadvantaged and marginalised communities, and that we're able to review and improve our frameworks as circumstances change and as our knowledge and experience evolve. So this includes understanding and harnessing interactions across different legal frameworks within the same jurisdiction, across overlapping jurisdictions, for example, national and subnational, as well as international legal frameworks, working effectively across government agencies and across sectors beyond what we might sometimes think of as health law and the health sector, working in partnership and collaboration with the community and with the private sector while regulating it. So in this session, we're going to discuss how we can build and mobilise the legal capacity that we need to be able to mobilise to do all of this effectively for the ongoing COVID-19 response, for health emergencies beyond COVID-19, and more broadly for health system strengthening and to achieve universal health coverage. So we've got a fantastic panel for this session. So I will, I think there's a slide, there might be a slide coming up with you all on it, maybe not, okay. So the panel, I'll mention them all now and then I'll come to them individually. So we have Professor So-Yoon Kim from the Asian Institute for Bioethics and Health Law at Yonsei University College of Medicine. We have Hayley Jones, who's the director of the MCCABE Centre for Law and Cancer, Miles Young, Director of Human Rights and Social Development at the Pacific Community, Dr. Rahani Jahis, Head of Zoonoses Control Sector, Ministry of Health, Malaysia, Delphina Kerslake, Assistant Chief Executive Officer, Legal Office of the Director General Health in Samoa, and Melee Tangivakatini, Government Lawyer, Department of Justice, Nauru. Now, so we do want to have time for discussion at the end and also some time for the Padlet. We've got 6 presenters, so I'm going to ask you all to try to keep to time. And if you do get to 10 minutes, I'll let you know. So first over to Professor So-Yoon Kim from Yonsei University College.
Thank you, Chair, and thank you for the WHO and Wipro team. Yeah. I'm very glad to participate this forum. In 2010, the former Director General of Wipro, Young-Soo Shin, requested to the Myung-Se Son, my senior professor, to send the legal expert to the Wipro office for supporting the each country's legislation. So I was sent, and then I worked as a legal officer at Wipro, Manila for 9 months. And in 2011, May, we host the legal expert meeting for supporting each country's legislative capacity building system setup. Genevieve was one of the coordinator, and David Clark was one of the expert consultant at the time. And from the time, myself and Yonsei University continuously involved with the legal activities of Wipro and became the WHO Coordinating Center for Health Law and Bioethics from 2014 until now. And from the 2011 May meeting, we continuously want to build up the domestic researchers and capacity building of each country. We provide self-analysis tool for analyze their own laws and set up the websites. And we also support to set up the Korean Parliamentarian Forum on Global Health and also Asian Pacific Parliamentarian Forum on Global Health. The reason why I present this history, it is very closely linked to discuss point of today. So I want to question and answer for this sections and part. So the first question was, how can you better demonstrate the role that the law plays in supporting effective public health emergency preparedness and response? I think that it would be great to examine a policy compliance and compare result with and without the presence of legislative measure. For example, about the self-isolation. In some countries, they have law for supporting the self-isolation, and in some countries do not have. And we can compare very closely. And how can you check the isolation, self-isolation is performed thoroughly? Someone should be able to monitor the person, whether the individual are self-isolated or if they are not, they should be penalty. Yeah. So, and in addition, someone should help the self-isolated person to live their daily life. So if we have only the legislation and do not have the infrastructure system for supporting or monitoring, the law cannot be safe. That infrastructure system cannot be set up by the social fund. So legislation is the first step for setting that kind of infrastructure and monitoring and doing the penalty for the violating the laws. So this kind of legislation and observation, the with and without the legislation, how the system can works is observation. That kind of things is very important, and that kind of things can be done by the government itself, but also can be done by the researchers. So research about these kind of observations is very important. And the second question was, how can you harness the lesson and attention on the roles of law to both supporting the ongoing COVID-19 response and strengthening legal preparedness for future health emergencies? I think it should be better to collect legal responses and experience from each countries and establish the knowledge and information share system. The system can provide not only legal ground, but also the practical information on infrastructure building and experiences. And for the third question, how can you ensure our approach to strengthen legal capacity and preparedness also contribute to broader health system strengthening and advanced UHC? I think the making of law means that the society as a whole realize its importance and feels necessities. This will be an opportunity to strengthen general health capacity by supporting the health response related infrastructure and manpower capacity building. So legislation itself is very important meaning for advancing the UHC, I think. And fourth, what action can WHO and development partners take to support those at a country level to strengthen legal capacity and implement needed law reform? I think the regular and continuous capacity building opportunity like this kind of forum, but it should be predictable and continuity should be done. Many participants may not be changed and added, just that be dropped. They can be the important rule in their countries. So this kind of activity is very important, and I already mentioned the set up the knowledge and information sharing system, network system, is very efficient for each country to learn from that. And what are the priority action for building legal capacity for health emergency partners, particularly at country level? I think at the country level, they also need the manpower build up, capacity building. So select the legal experts at the government level, academic level, and parliamentary level to continuity and continuous activity for capacity building and research and implementation about the health law field is very needed. Thank you for your attention.
Thank you very much, Professor Kim, for those remarks. So I think just what I took from that, some of the main themes that there are roles for both government and for researchers outside of government, how important it is for us to be collecting and sharing information so we can learn from one another. And I think you made a really important point about continuity. We need to be doing this on an ongoing basis. So thank you very much. Now I'll turn to Hayley Jones, who's the director of the MCCABE Centre for Law and Cancer. Thanks, Hayley.
Thank you so much, Jonathan, and it's a real honour to be part of the forum and to be alongside such distinguished speakers and participants. So thank you very much for the opportunity. I do have some slides which I think colleagues at WHO will kindly share for me. But to make a start, I would like to acknowledge the traditional owners and custodians of the lands that I'm speaking to you from today, the Boonwurrung people of the Kulin Nation, and pay my respects to their elders past, present and those emerging, and to all First Nations people who are joining us today. And next slide, thanks. As part of my presentation, I'd like to give some background on the MCCABE Centre for Law and Cancer and make some reflections on our work building capacity on the effective use of law in the fight against non-communicable diseases, and particularly thinking about how to harness these lessons and how they may be transferable to support the ongoing COVID-19 response and to strengthen legal preparedness for public health generally and for future health emergencies. So the vision of the MCCABE Centre is a world free from preventable cancers and in which all people affected by cancer have equitable access to safe, effective and affordable cancer treatment and care. And our mission is to promote the effective use of law for the prevention and control of cancer and other non-communicable diseases by building knowledge, expertise, capacity and networks at global, regional and domestic levels. And as my colleague Professor Kim was mentioning, we're also very proud to be a WHO collaborating centre. We're a collaborating centre on law and non-communicable disease, and we're proud to work with WHO colleagues and support member states in their efforts on using law for NCD prevention and control. And we're also proud to host the WHO Framework Convention on Tobacco Control Knowledge Hub on legal challenges to the convention's implementation. Our team is based across a number of places in Melbourne, also based in Fiji, the Philippines, Kenya and New Zealand. And I do have to pay tribute to the vision of Jonathan Lieberman in establishing our centre back in 2012. So well done, Jonathan, and we're proud to continue this work. Next slide, thank you. So cancer and other non-communicable diseases are still the world's leading causes of death and disability. And only now they're also making people more vulnerable to COVID-19. And the COVID-19 pandemic is hitting marginalised communities the hardest, just as NCDs do, underscoring the same inequities. And it was really interesting to hear Dr. Bismarck's reflections on that this morning. 8 million people died last year due to tobacco use, while the tobacco industry continues to encourage people to smoke despite a pandemic of respiratory illnesses. While there's been a high level of political commitment to take action on NCDs over the past decade in particular, including goals and targets set out in the UN political declarations and in the Sustainable Development Goals, significant effort has always been needed to make progress, and this is even more challenging in the context of the pandemic. In our work, we aim to promote empowerment and building the capability of individuals, organisations and governments to use law as an effective tool to prevent and control cancer and NCDs. And we use deep technical research to produce world-class thinking, spurring practical action to face cancer and NCDs head-on. We have a real emphasis on fostering collaboration to bring together the brightest and most passionate minds from all over the world to impact the prevention and control of cancer and NCDs. Next slide, thanks. So a key aspect of our work is a range of training and capacity building programs which we've run since 2014. And we've trained over 270 people, mostly government lawyers and policymakers from around 77 predominantly low and middle income countries to build capacity in law and non-communicable disease prevention. These were previously primarily in-person training courses, but we've now adapted to running online training and networking opportunities over the past 18 months. And I'd like to draw out some important elements of these trainings and workshops which are relevant to consider for other kinds of legal capacity building, such as for capacity building on law and COVID-19. We situate our training within broader frameworks and showing the connections between them, such as the Sustainable Development Goals, human rights, gender, trade and investment, and we don't just look at NCDs in isolation. Underlining this, we emphasise the importance of multi-sectoral coordination to achieve these goals. And as with the forum today, the two-way sharing of experiences is a really crucial part of our trainings and workshops. Participants are asked to present on their work as part of their training and often make connections and exchange information with peers, and we always learn such an enormous amount. For our intensive course, participants are asked to scope a priority project such as introducing and amending law or regulation in their home country. And we provide follow-up support for alumni and ask them to report back on progress on their projects. Predominantly, this is through support from our regional managers, who are lawyers qualified within their own regions and more familiar with the local context. And I mentioned our team is spread across multiple places. For us, having regional managers who are based in Fiji, Manila and Nairobi, supporting the Pacific, Asia and Africa respectively, is a really crucial element of our program and enriches our approaches to using law for NCD prevention and control and providing appropriate support for alumni. Additionally, another crucial aspect of this success has been having those fantastic partnerships with WHO, the Convention Secretariat and others, particularly in the nomination process and choosing who will come along to our trainings. The WHO has been very useful in supporting that nomination process and helping us to identify who is best placed to apply the lessons of the training, have buy-in for priority projects and have the appropriate role within government. Next slide, thanks. So through this training work and other projects over time, we've built a really strong network of MCCABE Centre alumni who are working to use law to address cancer and NCDs in their countries. We've also had follow-up alumni workshops and other online activities, and our alumni from our past trainings contribute to subsequent training programs and also as part of webinars and international fora. And as Professor Kim was mentioning before, that knowledge sharing is a really crucial part of developing this network. Next slide, thanks. So we've celebrated some really great successes of our alumni as they work to develop legal and regulatory frameworks around the world. Alumni from, I think it's now 22 countries, have successfully implemented laws or regulations aimed at NCD prevention. For example, alumni in Malaysia have contributed to laws for smoke-free environments in restaurants, and alumni in Vietnam have contributed to comprehensive alcohol control laws. And alumni in 6 countries have also gone on to successfully defend laws, for example, from legal challenge brought by the tobacco industry. And obviously law reform can be a very slow process. Many of these projects have taken many, many years, and there are many more projects that are in progress, and our alumni continue to work behind the scenes. And we aim to keep providing that support over time and to encourage alumni to keep going with those projects. Next slide, thanks. So I'd like to close with some comments on how we further adapted our work over time to respond to feedback and other changes we've made, such as the impact of COVID-19. So over the past 18 months, as I mentioned, in-person training hasn't been possible, but virtual learning has created new possibilities for us. For example, our online training program has allowed a much wider geographic spread of participants in our programs, and we've actually been able to have triple the amount of people participating at a much, much lower cost. So that's been brilliant to increase that reach. But at the same time, there's been some drawbacks, such as some of the networking and relationship building has been impacted by only interacting online. So we continue to adapt and change, and we've adapted our programs throughout to address participant needs using both formal and informal feedback methods, such as through the regular check-ins on priority projects. And then last year, we also ran an informal survey for alumni on how their work had been disrupted by COVID-19. And following that survey, we set up a specific 2 webinars in 2 different time zones to address some of the key issues on the impact of COVID-19 that alumni had raised. Many of our alumni, being lawyers in government health departments, had been refocused their work onto the COVID-19 response. So we felt it was really crucial to support that work. Another key adaptation to our course, which we made over the past 18 months, was to include specific information on the links between COVID-19 and NCDs, and also introduce a new unit on universal health coverage and NCDs to better draw connections between these issues and emphasise how progress on universal health coverage and NCDs is a mutually reinforcing approach. And I guess the other key point that we've tried to emphasise over the past 18 months is to make sure that cancer and NCDs remain on the pandemic agenda. COVID-19 makes cancer and NCD prevention and control more important than ever, and law continues to be a crucial tool going forward. At the same time, we've seen industries behind NCD risk factors like tobacco, alcohol and unhealthy foods have seized on the pandemic to push misleading information, such as, for example, that nicotine may limit the spread of COVID-19, or to market themselves as socially responsible and to aim to partner with governments, international agencies and NGOs hoping to influence policy in their favour. As we work to overcome this new challenge, we can't forget our existing public health toolkit and make sure that we double down on prevention and make use of the legal and regulatory tools that we already know about, that we know are really effective, as outlined in the WHO best buys. And we also need to adapt to deal with the growing challenges such as the spread of health misinformation, which has been mentioned by a few of the forum participants. Has always been an issue in a cancer context, but it's significantly more serious in light of social networks and COVID-19 and the ease of sharing information. So this is something that we're addressing in our work as well. And finally, I've already mentioned how important partnerships are to us, but it's important to keep nourishing those partnerships and collaborations and to find new opportunities to connect and to maintain those key relationships with WHO, various governments, SPC, and that's really, really crucial. So we're excited to be also adapting our training to provide a course focused on building capacity in law and non-communicable disease for civil society advocates. And that's going to be launched next year alongside, together with the Union of International Cancer Control, and made available to their members in April.
Hayley,
So
can I ask you? Yep.
Yeah, I'll just wrap up.
Okay.
So finally, just to reiterate the importance of taking a long-term view. Law reform takes time, this relationship building takes time, and we can't shy away from this and the investment that's required to see real change. At the same time, I think during the course of COVID-19, we've seen laws introduced and changed at speed, which has probably been unprecedented in a public health context for many, many years. So there is a real opportunity to galvanise this time to make sure that effective change is made, but we can't shy away from that investment that's needed and recognise that sometimes it will be a time-consuming process. So we stand ready to continue supporting countries to strengthen their capacity to develop, pass and enforce public health laws. And we really want to make sure that we can keep fostering those networks for people working on public health laws to share knowledge and build on success. Thanks very much.
Thanks so much, Hayley. So I had made a few notes, and I think you mentioned them all in your closing there. So I would just reinforce the importance of partnerships and networks. that law reform can be a slow process. So we do need to be in it for the long term. We need the kind of continuity that Professor Kim was talking about. And finally, I think both the opportunities and the challenges of moving to online virtual learning, and I guess we'll be transitioning to a time where there'll be more international travel again, and we need to work out the best way to do both in-person training and remote networking and connection in a complementary way. So thank you very much. And now I'll invite Miles Young, Director of Human Rights and Social Development at the Pacific Community.
Thank you very much, Jonathan. First of all, I'd like to congratulate the World Health Organization for organizing this forum on law and COVID-19. And Vinava Levu, thank you very much for the opportunity to contribute to this panel discussion. For those who may not be aware, the Pacific Community, or SPC, is a regional intergovernmental organization. We have 26 members comprising 22 Pacific Island countries and territories, plus what we call our metropolitan members, being Australia, France, New Zealand, and the United States. Our work is to support our 22 Pacific Island countries and territory members with their development priorities through the provision of technical assistance, capacity building in areas like public health, agriculture, land resources, in fisheries, maritime resources, geosciences, climate change and the environment, and the area in which my division leads, human rights, gender equality, social inclusion, and culture. And particularly through our public health division, SBC has worked closely with Pacific Island countries and territories in responding to the COVID-19 pandemic, including in close collaboration with our friends at the WHO and other UN agencies like UN Women and UNICEF. I thought I'd start, I have a slightly different approach to my presentation, and I thought I'd start by mentioning that in the early months of the pandemic, 13 Pacific Island countries declared a state of emergency. They implemented a range of measures to protect their people, prevent the spread of COVID-19. And primarily these were stringent border controls, quarantine requirements, internal travel restrictions, the closure of schools, and social distancing measures. What is interesting is that some of these emergency measures are still in place, some of them close to 18 months after they took effect. And in the context of this forum, which is around looking at strengthening legal responses to health emergency phenomena like COVID-19, I think one of the key questions to consider, at least in the Pacific, is the extent to which the so-called Syracuse principles are incorporated into these international laws in the Pacific, which govern emergency responses. In other words, to what extent are these emergency measures reasonable and proportionate? To what extent do they maintain the respect of human dignity? Are they subject to timely and systematic review? So the question is, to what extent are the Syracuse principles incorporated into national laws in the Pacific? But perhaps more importantly, how are these principles applied? They may be in the law or incorporated into the law, but how are they applied, and how will, and perhaps most importantly, how well do our communities understand and appreciate the principles, especially in relation to the reasonableness of measures and the need for these measures to be subject to timely and systematic review. There's a danger, of course, that restrictive measures of the kind introduced during these unusual times, pandemic times, which are, as we all will concede, are very unprecedented times. The danger is, of course, that they will become accepted by communities as the norm, and I think that's something that we need to be very wary of as we ponder the question which this forum is considering. Now, interestingly, in Fiji, the prosecution of curfew infringements came under the spotlight when a court highlighted that a number of those punished were unable to pay their fines and would disproportionately suffer as a result. I understand that this case is a subject of an appeal, but the other thing to point out is that early on during the pandemic, breaches of curfew resulted in convictions being recorded. The courts are taking a slightly different approach now, 18 months on. But one of the key questions for many of us to consider is the impact on the future of those against whom convictions were recorded for curfew infringements, for example. Some of which may be considered to be relatively minor infringements. What impact will that have on future prospects of employment, migration, if they wish to move on to, if they wish to migrate to other countries, etc., etc. Some of you may be aware that there is a no jab, no policy when it comes to the civil service, and in the private sector, it's a mandatory condition of work. The impact of that is that many people have lost their jobs because they have not been vaccinated. Interestingly, the Ministry of Health and Medical Services has terminated the contracts of 50 plus medical personnel because of this policy or this mandate. Many in the private sector have also been had their employment terminated. Interestingly as well, after the no jab, no job policy was introduced, there was a significant increase in the vaccination rate. So, you had on the one hand an increase in vaccination rate, and then on the other, you had these consequence, this consequence of people losing their jobs because of an unwillingness to be vaccinated. It should be interesting. There is a case which is before the courts, which is challenging this no jab, no job measure, and it'll be interesting to see what the final outcome of that. Just very quickly, I also wanted to just talk to violence against women or domestic violence. The Pacific has some of the highest rates of violence against women and girls in the world. The evidence suggests our rates are close to twice the global average. And in the early months of the pandemic, there was an increased demand for domestic violence support services. In Samoa, for example, helpline calls jumped 150% from the same time the previous year, while in Fiji, the National Domestic Violence Helpline recorded a 500% increase in April than it did just prior to COVID-related measures. So significant increase there. The emerging evidence is that this trend points to women and children being confined for longer periods at home due to job losses, restrictions on movement, and the job losses have led to increased financial pressures on families, which can act as a trigger for family violence. So again, it raises an interesting question around the consequences and impacts of lockdown measures. And clearly, the increase in domestic violence was not an unintended consequence, but clearly it appears to have been. And the third example, or the third point I just wanted to raise quickly, is in relation to access to education. Like in other parts of the world, the widespread closure of schools has impacted school children. Access in the Pacific, access to education during lockdown has been very uneven. There are clearly schools and families with access to the internet and to devices which allow for online education, but a significant portion of our communities do not have access to good internet and to devices, while multi-generational extended families, which is common in this part of the world under the one roof, impacts the ability to learn at home. So those measures around school closures and the restriction of movement has had an impact on education. So I think what I wanted to highlight these examples because it comes to my point, which is that the need for any legal response to addressing a health emergency phenomena like COVID-19, I think needs to apply a people-centered approach, or an approach which is informed by a rights-based approach, by gender and social inclusion considerations, by cultural considerations, needs to be considering socio-economic, political considerations as well. And I think, a people-centered approach in any legal response or any legislative framework is not to diminish in any way the health and the technical considerations around health when it comes to something like COVID or any health phenomena, but to marry these health and technical considerations with the considerations which I've just mentioned. So it's a balancing and a marrying of these considerations, not having one take precedent over the other. And of course, as you all know, Secretary General Guterres has been very clear about the need for human rights to be central to any COVID-19 response. I just wanted to very quickly, just looking at the some of the framing questions, I thought I just wanted to, before we move on, just to very quickly
Miles,
touch
can
on.
I give you 2 minutes?
Yes, very quickly. There was a question here. The first question is around how do we better demonstrate the role that the law plays in supporting effective public health emergency preparedness. And what I wanted to quickly mention here is that we often develop and implement legislation, but what is often forgotten is the need to continuously monitor and evaluate. And in this case, any legal response or legislative framework. I mean, laws are passed, frameworks are developed and implemented, but we don't give enough attention to whether they are achieving their objectives. So I just wanted to quickly point in the limited time that I have left to say that consistent monitoring and evaluation is an area which I think more attention is needed, and I think it also allows us to implement real-time pivots to our responses when this is necessary, by referring to the data, by referring to what's happening, because we've got real-time information to be able to take those decisions. Thank you, Jonathan. I have taken up too much time already, and hopefully there'll be further time to unpack some of these points.
Yeah, thanks for a great presentation, Miles. So a few things that came out of that for me. So really reinforcing the importance of a rights-based approach, people-centered approach, needing to monitor and evaluate the laws and the implementation. And I think in particular, as you've pointed out, some really serious unintended consequences, increases in violence against women, effects on education. But then also I think a really interesting point about not just the laws, but the norms. So as countries do transition out of this emergency situation, so we need to look at both the laws that we'll be amending, and also what norms might have changed over that time, and what we do to then try to move away from some of the norms that might have been appropriate in emergency situations, but really shouldn't be ongoing once we're out of that kind of crisis. So thanks very much for your great presentation. And now we'll turn to Dr. Rohani Jahis, Head of the Zoonosis Control Sector at the Ministry of Health in Malaysia.
Thank you, Mr. Chair. Assalamualaikum and very good morning, good afternoon, good evening, ladies and gentlemen. So this is the question given to Malaysia. Okay, so basically overview of the legislation in MOH. Actually, we have 28 acts under the purview of MOH for management of COVID pandemic. Actually, there are a few legislation that were used. Basically, one is the Prevention and Control of Infectious Disease Act 1988 to manage case, contacts, and control the spread of disease. And we have the Sale of Drug Act 1952 and Control of Drugs and Cosmetic Regulation 1984 for managing vaccines and monitoring AAFI for vaccination, COVID vaccination program. So in MOH, all the legal issues are dealt with the advice from the Legal Advice Office, which is under the Director General. We were sort of lucky that prior to COVID-19 pandemic occurrence, Malaysia have undergone a joint external evaluation of IHR core capacities. And one of the scope that was evaluated is related to legislation. So in managing infectious disease, crisis or pandemic, beside the Prevention and Control of Infectious Disease Act, the National Security Council Directive number 2020 is used in managing major outbreaks involving multiple districts and states. This directive is under the Office of the Prime Minister, and it's really facilitate the involvement of other ministries and agencies for a comprehensive whole government approach, as mentioned by many speakers before. So for COVID, this National Security Council Directive number 20 was activated. And from the audit, the auditors recommended that we should conduct a holistic assessment of the implementation of national legislation and state legislation, regulations, and other legal documents in a systematic and coordinated manner to ensure they support the government-wide implementation of IHR 2005. So, before we could assess the legal documents, we faced the COVID pandemic, and we take it as an opportunity for us to review the legislation related to infectious disease pandemic as a whole. So, as mentioned, the Prevention and Control of Infectious Disease 1988, or we call it as Act 342, covers all 15 states in Malaysia, and it's been used widely for notification and management of 31 infectious diseases. And it was also used in managing Nipah outbreak and H1N1 pandemic without any issues, because those two outbreaks were considered small and the impact to public health was not so great. But however, during the COVID-19 pandemic, it was used extensively, and many SOPs and regulations was made under this act, and it shows how flexible and adaptable the act to the current situation. And during this outbreak also, COVID-19 was made notifiable, mandatory notifiable. So it makes the notifiable diseases to 32. And in early of this year, when the number of cases, COVID cases escalated here in early of the year, and the health delivery system nearly collapsed, emergency ordinance was enacted, and health emergency was declared in order to support the management of the COVID pandemic. So through this emergency ordinance, there's a provision to obtain support from non-MOH health services providers, basically the university hospitals, private hospital, as well as laboratories. And through this emergency ordinance also, we make the cost for testing affordable and can be obtained by all walks of people. And this ordinance also support the implementation of the acts and regulation to contain the pandemic. As I mentioned earlier, this pandemic is an opportunity for us to assess the Act 342, and I share with you some of the issues noted during the pandemic. First, we know that the extent of the pandemic is quite great, and we need extra manpower to manage cases as well as to enforce the act. So in order to enforce the act, in the current act, it just mentioned public servant from other ministry or agencies could be appointed as authorized officer. And we found that actually it's not enough for us. So we make amendment to the ordinance to include private practitioners and district officers to be as the authorized officer, as to assist MOH in issuing health surveillance order, as well as to manage the cases and contacts in the community to ensure that they abide to the instruction given by the authorized officers. And then number two, we know that during a big massive outbreak, we need to contain the cases and as well as contacts. So we declared all states as local infected areas to facilitate movement, order, control. So it was successfully reduced the number of cases in the first wave. However, there was a thought to declare other countries as infected areas. However, because of economic impact and also G2G relationship, so it was never been declared. But the provision was there in the Act. The declaration of infected local areas also assists us in border control activities. Okay, number three, with the, as mentioned eloquently by Prof. Wang just now, it is very important to regulate people to abide to the non-pharmaceutical intervention, basically the public health measures. So the DG of Health was given the power to develop SOPs that are binded by law and need to be followed by the community. And it goes the same to the minister, who can make regulations which gave us opportunity to control the pandemic better. And another important thing in this current era is the digitalized technology. So with our present Act, the surveillance of COVID is done, surveillance of diseases is done manually, meaning they have to submit the notification form or doing the phone call. But then during this COVID-19, we know time is very important. So the digitalized integrated surveillance system was built and it became the source of notification. So we changed from manual to digitalized, and it is made legal by the law. Okay, number 5, that we noticed the order for isolation and observation of COVID cases. In the Act, it was mentioned that all the quarantine should be done, all the isolation should be done in quarantine station. And the quarantine station including the hospitals, and it goes for all cases regardless whether they have symptoms or asymptomatic. But when the number of cases were overwhelmed, isolation of cases need to be done at home and with strict enforcement. So then we make amendment to the Act through the emergency ordinance to allow cases to be isolated at home and being followed up by the practitioner, either from public or from private setting, to ensure that the patient are healthy throughout the isolation period. And referral were made where if the condition worsened. And another thing is for quarantine as well as isolation, patients are required to wear a tracking device. So this tracking device is to ensure that those are ordered to stay at a set address to be there all the time during the isolation period or quarantine period. So this wearing of tracking device will also put into the emergency ordinance to ensure that we are covered by the legal side of this new provision. Okay. These are a few of the issues that we noted during the management of COVID-19 pandemic until now. There are a few more that are small, and I won't share it here because of limited time. So moving forward with all these findings and observation of the legal requirement for better management of infectious disease pandemic in future and part of preparedness, we put up all these provisions into the amendment of the Prevention and Control of Infectious Disease Act to be tabled soon in Parliament to ensure that the continuity of the enforcement of the provisions during the emergency ordinance will be continued once this ordinance is revoked. I think that's all. Thank you.
Thank you very much, Dr. Jahiz, for an excellent presentation. A few really brief comments. I think you also mentioned the importance of evaluation, as Mild did when you spoke about started off with the joint external evaluation. I think we saw the importance of ministries and agencies outside of health, mobilising personnel from those agencies, and the importance of flexibility within our legal frameworks and to be able to respond and adapt quickly as the situation evolves. So thank you very much. And now I'd like to invite Delphina Kerstlake, Assistant Chief Executive Officer, Legal, the Office of the Director General Health in Samoa. Over to you, Delphina.
Talafalavan, greetings, everyone. I see so many familiar faces. Hi, Jonathan, and names, and I'm happy to be part of this forum. So for the topic for today and contribution, so how can we better demonstrate the role that the law plays in supporting effective public health emergency preparedness and response? So COVID-19 has taught us many lessons, and it has made us realize whether there were effective laws in place to deal with the pandemic. And from listening to the various country experiences that have been shared during this forum, we have seen many utilizing different instruments, some emergency powers under their constitutions, public health laws, disaster management laws. And the bottom line that I think we've all realized that having a proper legal framework is paramount. Having an effective legal framework in place for any type of outbreak, diseases, epidemics, or pandemics, of course, will always assist public health emergency and responses. For Samoa's experience, we did use our emergency powers under the Constitution, and as well as one of our very old and ironically relevant public health laws, our Health Ordinance of 1959, which also helped us to legally be able to respond to COVID-19. With this being said, we had just come out of a measles epidemic. So for the climate at the time for us was current, was relevant, and it we already had a snapshot of what needed to be done to assist in combating COVID. So what are the lessons that we had learned and the attention on the role of law to both support the ongoing COVID-19 response and especially to strengthen legal capacity? And the lessons learned is there should always be a good, solid planning framework that assists all relevant stakeholders to guide them, as well as inform on the limitations and the boundaries on what we can do and what we cannot do. And this can be done, for us, it's in the form of a national country level plan that deals with pandemics. And further to the plans and the policies, this helps inform the law, which mandates us to act in a legal way to control and combat COVID-19. I know the one thing we have learned, and I've heard from several countries, is that we now all are able to identify the gaps in our laws and have possibly made plans to address those gaps, given the experience of COVID-19. And the importance of laws, a simple example is COVID-19 is spreading internationally. We want to close the borders. Do we have the necessary legal powers to do that? Do we have effective laws to restrict movement? How do we weigh that with fundamental and human rights? Do we have the necessary laws to close down schools and public places in our own jurisdictions? In times of pandemics, law is important because it is the tool or the instrument that people have come to understand, people have come to obey, have faith in, hopefully, and offers guidance as well as control measures on how society can address these type of events. And then as always, we have to balance the interests of public health versus the individual right. Where do we weigh this? We also, and I know in different countries, have national committees which are led by the main leaders of the country, involving all relevant government and non-government actors and involving civil society and NGOs. And most countries use these legal capacities to address this pandemic, as well as ensuring access to health for everyone. The multi-sectoral approach is important in the context as no one can act in silos in events such as public health emergencies. So how do we use this opportunity to ensure our legal frameworks better protect and promote the health of the marginalized and the hard to reach groups or the vulnerable groups during emergencies and at all times? With this pandemic, we have also realized the need to protect whole of society, and the concept of health in all policy, which has been around for the last decade or two, has now become fully realized how it is important that access to health may be obtained by all. In certain communities like Samoa, how did we reach out to the disadvantaged, marginalized, and hard to reach groups? We worked within our cultural context, but that is what works for Samoa. Different countries have different methods. So the involvement of community, the empowerment of local leadership, the principle of collective responsibility, and having proper frameworks to address the needs of these vulnerable groups. So the Pacific Way, the family, operates in a communal way, and that's how the concept of collective responsibility works. And that concept helped us prevent COVID-19 from entering our shores. We're still COVID-19 free. It has helped us for people to access vaccination through vaccine campaigns and drives, and also ensuring access to health facilities. So how do we move forward with this? Well, of course, we need help. We always need assistance, whether that is in financial or technical form from WHO and our development partners. This is where they may assist. Legal capacities need to continue to be developed and to help inform law reform. We have the IHR, the International Health Regulations, which guides countries and member states on how to deal with outbreaks, and epidemics, and pandemics. And also, most importantly, the notification of diseases is very important because of travel and trade. We also need this to be reflected in our national laws in our own respective jurisdictions so that we are legally able to enact this. So in closing, I know I'm almost last, so I thought I wouldn't be long. We need to continue to build legal capacity for health emergency preparedness and response. I don't think anyone expected COVID-19 to last this long, and who knows how much longer that it will be, but we have to adapt and we have to learn and live with that. We have truly learned what it is like to live in a global pandemic, firsthand experience for many of us. And the words isolate, quarantine, vaccinate, prevention, PPE have become our everyday language. So the important points that I've taken during this experience is multi-sectoral approach. You know, the whole government approach is very important, with including our non-government actors, civil societies and NGOs in our communities are just as important. Good sound policy and legal frameworks, resourcing and financing, because not all countries are at the same level playing field. Others have more resources than others. And this is where also our regional organizations and development partners may assist. And of course, collective responsibility, because this cannot be solved on our own or by a few countries. The approach is global and the remedy is global. And therefore we are all obligated to help one another. And thank you for the opportunity to participate in this forum.
Thanks so much, Delphina. Lovely to see you too. I think some of the main points of this really is an opportunity for us to be identifying those gaps and making plans to address them. I think you really articulated the importance of cultural context. Things are different in different countries, and that what we do needs to really work in our own local setting. That whole new language that we've learned, those words that you mentioned, many of us have not really been familiar with before. That's an opportunity to what do we do with that new language and that learning. And then, as you said, the importance of resourcing and financing our preparedness and response. So thank you, Delphina. So over to our final speaker, Mele Tangivakatini, Government Lawyer, Department of Justice in Nauru. Over to you, Mele.
Thank you, Jonathan. Mojeko, and good afternoon to everyone. My name is Mele Tangivakatini. Joining me from Nauru Justice is Wiley Detenamo. We will try and do our presentation within the time allocated given to us. On behalf of the Government of Nauru, we would like to give our sincere thanks to the organizers for allowing us to be part of this forum. In my presentation, there will be 6 core issues I will try and discuss. So the first issue would be the role of laws and legal advisors played in the COVID-19 response in Nauru. You will note that from my presentation, it will be specific to Nauru context. The lessons we have learned as well, the capacities that might need to be strengthened in the future, what has worked well for Nauru so far, the challenges we have faced, and also any support that may be required from international agencies, including the World Health Organization. Now, in terms of the COVID-19 for Nauru, I remember late in 2019, when we started receiving news of a new virus, a travel advisory was issued by the Department of Justice to restrict travel from certain countries. This was done as an interim measure by the government, awaiting the decision by the WHO on whether COVID is a pandemic or not. In terms of the laws for Nauru, when COVID-19 hit, we had to go and identify the laws that were already in place that were necessary to ensure that at least we have the legal framework for the purposes of COVID. One of the laws that we still have in place is the Notification of Infectious and Contagious Diseases Ordinance of 1923. The second one is the Sanitary Inspectors Ordinance of 1921. We still have the Quarantine Act of 1908 and the Agricultural Quarantine Act of 1999. So from there, you will note that most of our laws relating to health are quite old, but fortunately for us, we do have a law, which is the National Disaster Risk Management Act of 2016, which enabled us to at least, which is the basis, the legal basis, which allowed us to make laws, further laws relating to COVID-19. So on March 16th of 2020, there was a declaration by the President, who is also the Minister for National Emergency Services. This declaration was not made under the Constitution like most countries. Our declaration of national emergency was made under the National Disaster Risk Management Act of 2016. So this declaration, since it came into effect on 16th March of 2020, it has been extended every 30 days. So once we have our declaration in place, we had to identify, and a decision had to be made to ensure which department should be responsible for the purposes of COVID-19. Though the Department of National Emergency Services under our National Disaster Risk Management Act has the mandate to implement the act. For the purposes of COVID-19, the decision was made from the initial stages that it should be the Department of Health and Medical Services to take the lead in the fight against COVID-19. So after we were able to identify the responsible department, then we had to make additional laws. So from there we had to, because we did not have any specific law that that allowed us to at least have a legal framework in our fight against COVID. So from the declaration, we managed to have a number of regulations made. So before the regulations were made, a national coronavirus task force was formed. This included members of the different sectors of the government with a strategy to capture and contain at the border. This is so due to Nauru's location, which is in the Central Pacific, and with the closest neighbor being Kiribati, which is about 200 miles to the east, and also on the fact that our population of about 12,000 and a land size of about 21 square kilometers. So you would understand, due to these factors, we had to make, the government had to make the decision in terms of the laws that need to be made to ensure that our people are protected from the COVID-19 virus. In addition, subcommittees were formed as well to assist the task force in its work on specific matters, whether it be health, border, or community issues. Now, on 19th of March of 2020, we had our first COVID regulations. These regulations allows for the management and minimization of the impacts of COVID-19 at the border. This also ensures and enforces the declaration that was issued by the President on the 16th of March of 2020. In terms of these regulations, it required all travelers, whether they be Nauru citizens or foreigners alike, to Nauru to be at a designated residence for 14 days. And this was later reduced to 5 days based on information from WHO. In addition to the first COVID regulations, we made rules as well for the occupants of the designated residence. Now, when we were making these regulations, we identified 3 types of designated residents, which are the transit station, observation station, and the treatment station. The transit station is for screening or testing of COVID-19. Observation station is for anyone who presents any sign or symptom of COVID-19. The treatment station is for treatment and hospitalization of anyone found to have gotten COVID-19. Now, for all these travelers, the government covers the expenses for keeping them in designated residence. This includes food and free Wi-Fi. One of the lessons we learned from the first COVID regulations we made was that additional laws would be required if community transmission occurred. While we have managed to capture and contain the virus at the border, another set of regulations were made to cover community transmission issues. Nauru only has 1 international airport and seaport. We have 12 districts, and like in any other Pacific Island country, most of us live with our extended families. Also, we have a high rate of NCDs like diabetes, and it was important that the legal framework for COVID-19 be reviewed and updated. Apart from the laws, more health officials were recruited from around the region. Now, on 4th of May 2020, we managed to have our community transmission regulations. These regulations supplement the first COVID regulations as well as the declaration of 16 March. With these community transmission regulations, we were able to conduct public awareness with frontliners, public servants, and the community. Several trainings were conducted for the police and health workers to make them understand their legal responsibilities and so forth. With the coming into effect of the community transmission regulations, the task force and with the assistance of other stakeholders, we started having practice community tracing, practice drills of an outbreak from a remand center, the hospital, from a district, and from transit station. This was done through public notices where we issue updates to the public, and also debriefing were done on lessons learned and areas to improve on are discussed after each practice drills. The community transmission regulations also encourage voluntary action by all citizens and residents alike. In addition to the potential community issues that may arise, we were confronted with another issue. These were the seaport and airport border issues. There was a lot of close contact between the crews of aircraft and vessels, as well as those personnel from the ground, though we had some laws in place relating to customs and immigration. They did not have enough mechanisms for the purposes of COVID-19. In 20th May 2020, we did another regulations, which was the ports regulations. And it was necessary to avoid interference with the loading and offloading of cargo at the airport and seaport. Further, it also provides for the control of embarkation and disembarkation from a vessel or aircraft. It also allows for the screening and examination of crew members, as well as contact tracing on vessels and aircraft. Apart from the ports regulations, we did another regulations, which was the Maritime Security Prohibition Regulations, which came into effect on 1st May of 2020. This was to ensure that and also prevent a person from approaching or boarding any ship in our waters, take or cause another person to take any material onto a ship, and also to prevent another person from removing any material from a ship in our waters. Furthermore, when the borders were closed in 2020, a number of foreigners were stranded in Nauru. We have flights to Fiji and Brisbane, and when both Fiji and Australia closed their borders, we were basically locked out. The government deemed it necessary to help. This resulted in the making of a COVID-19 visa regulations, which came into effect on 20th May of 2020. This allowed for the issuance of temporary visa to our foreigners to enable them to remain in Nauru until the border restrictions have been relaxed and international travel is allowed. Now, recently on 20th March, we made our vaccination regulations. These enable vaccination and vaccine usage. In May, we conducted our first vaccination drive, which resulted in the vaccination of around over 7,000 individuals, basically adults, including foreign nationals. Yes, in terms of the challenges, one of the main challenges for Nauru during this COVID time is shipping and food security. About 90% of our food is imported from Australia, Fiji, and the Solomon Islands. And when a vessel fails the COVID clearance, our food on the island is affected, and also food prices increase. And our future plans is to have a public health bill instead of relying on the National Disaster Act, and also to have a Biosecurity Act. So just to wrap up, government support is key, and we continue to be given such support for the management and minimization of COVID-19. That is all from now.
Thanks so much, Malay. So a couple of thoughts. I think you really illustrated how difficult that balance is between controlling the borders, but also allowing in essential imports, food and other essential supplies. And I thought also you spoke about how important it was for to have police, health workers, others trained in the law, and it was great to hear about those the practice drills as an example of training. What we want to do now, it's because it has been a bit hard to discuss in a group of this size. We want to just give a few minutes for people to look at the Padlet and to provide some comments on the Padlet. Alyssa, are you able to share that? So the last I looked, we had one comment on the Padlet. But we'd like to give about 5 minutes for people to add some written comments. Okay, so as we're waiting for some comments to appear on Padlet, Did anyone want to ask any questions of the panelists? We'll have a few minutes if people would like to do that. So there's also an invitation for any of the panelists who would like to respond to anything that they heard from the other panelists. Professor Kim.
Yeah, can I ask what is the next step after this forum? Can you make a discussion or? Yeah.
We'll do, Wipro will wrap up in the next session. So we'll definitely get to that. Miles?
Thank you, Jonathan. I had a question for Delphina, but also to all the other panelists. Thank you, Delphina, for your presentation, and thank you to all the other panelists for their presentation. But Delphina, you mentioned culture and the cultural context in your presentation, and to me that's very important. You know, at SPC, our work is very much underpinned by cultural considerations, as I mentioned, but didn't really expand on in my presentation. So I just wanted, and I know in Samoa, you're very, very strong on culture. You know, Fa'a Samoa is very, very strong. I mean, that's not to say that it's not strong across the Pacific, but I just wanted to just unpack that a bit more from you in terms of your cultural, when you were taking into consideration culture, what are some of the things that came up in those discussions or in those considerations?
Okay, thank you, Miles, for the question. Yeah, I think sometimes us that live in the Pacific take culture for granted because it's our everyday life. It's just the way we do things. So if I'm correct, if I understand the question is unpacking a bit on the culture, on helping to address what's going on. Okay, so yes, because it's a set up in the particular societies, in Pacific societies, where you have the local setup in the communities, and also the relationship that the local community has with the government, and also that relationship with civil societies and other NGOs, and all culture, and all these different groups play different roles, and all these roles complement each other. So perhaps I could use an example. We had a 2-day lockdown where everything closed, public and private, to get our vaccination numbers up. And before we went out into the districts, it was a national, we managed to, well, we're a small country, only like 200,000. But on the 2-day national lockdown, we managed to vaccinate 20,000 in 2 days. And that was because of how everyone worked together. So when we went out into the villages through our own cultural context of communication and public relations and all that, everyone was prepared because the local councils had already prepared, and they assisted government on how to carry out that role. And I think it's a lot to do with awareness and education. And once people come to a basic understanding that it's a collective responsibility, and it's just the method that we need, it's actually the remedy, or vaccination is actually the answer right now in our world, then they tend to come and comply and also agree with it. So perhaps with our 2-day lockdown, using that cultural context and using the communication with all the different spectrums in society, we were able to do that.
Inaka, Delphina, thank you.
Thanks, Miles and Delphina. We've got time for one more comment or question. Anyone from the panel? I see a couple more comments have been added to Padlet, which is great. Okay, should we leave it there? Okay. So thanks everyone for your great presentations. That was a fantastic session, and I know that will really help Wipro as they think about what the next steps will be. So we'll come back in just under 15 minutes at 12:30 Manila time for the final session. Thank you very much, everyone.